Good afternoon. I'm Claire Guthrie-Gastanaga. I'm the Executive Director of the ACLU of Virginia, and I'm pleased to be here this afternoon with my colleague, Nicole Tortoriello, who is our Secular Society Women's Rights Advocacy Council. And we're here this afternoon to talk to you about some exciting new changes in Virginia law that go into effect on the 1st of July and will finally move Virginia into the 21st century in some fundamentally important ways. So, Nicole, do you want to get started and talking about the Virginia Values Act?
Yes, of course. Thanks, Claire. So yeah, like Claire said, I'm the Women's Rights Advocacy Council, so I do all of our gender-related work here in Virginia, and we had a lot of really exciting wins for gender equity this past session, so I'm excited to highlight some of them. Ingrid, do you want to go to the next slide?
I think it's, really important. Maybe we should begin by emphasizing the historic nature of what's happened, because I think a lot of people don't understand how broad in scope and how really incredibly important the changes that we're going to talk about are. Virginia did have and put in place in the 90s something called the Virginia Human Rights Act, but it was basically a statement that it was against public policy to discriminate in Virginia. But there was no there. There was no way, if you thought you had been discriminated against in violation of public policy, for you to get any relief or to hold anybody accountable for doing that. There was no enforcement mechanism. And for many, many years then, Virginia has been one of 4 states in the country without a meaningful civil rights enforcement an enforceable civil rights statute in the state that allows residents of the state to vindicate their rights in state court. And now we actually have something.
Yeah, and that's exactly right. Under the old law that's still in effect for 6-7 more days, there was a teeny tiny little carve out, one tiny area you could sue, but it was so tiny that, as far as I can tell after searching quite far and wide, I'm the only attorney I know that tried to use it.
And that is because, some trial lawyers were successful in saying that if you were discharged in opposition to that express public policy that was in the statute, you should be able to recover in what's called tort, in a tort claim. And they brought a wrongful discharge tort claim, and they were successful. So the legislature turned around like almost immediately and added this little tiny narrow little provision where you could sue if you were fired. But as you said, they attached such limited recovery and so puny attorney's fees that the purpose was to keep people from suing, and that's in fact what it did.
Exactly. And so excitingly, the Virginia Values Act is a big landmark piece of civil rights legislation that was passed last year and is going to give new protections in several different areas. Employment is the one we've been discussing most heavily. It's where up until now I've done most of my work. But it also has protections in housing, public accommodations, and credit. And a whole bunch of different classes of identity are protected under the new law. So the slide that we have up lists them all out, but I'll read them quickly because it's exciting to see just how much is covered under this new law. So you've got age, race, color, religion, national origin, sex, pregnancy, childbirth or related medical conditions, marital status, disability, sexual orientation, gender identity, and status as a veteran. And I think a lot of the press coverage focused a lot on sexual orientation and gender identity as new protections that are super important. It's the first time that they've been added to Virginia law explicitly. We're the first Southern state to extend these anti-discrimination protections explicitly to the LGBTQ community. So that's really exciting, and it's definitely worth highlighting, but we don't want to forget that all of these other groups also got some new protections under this law as well.
Yeah, until this statute passed, the Virginia General Assembly had never codified protections for any of these groups of people in the code. There were some grievance mechanisms for local government and state employees, but the governors of the have mostly done executive orders, saying you can't discriminate in state employment, but that didn't even have a private cause of action. So, this is really the first time that all these groups can look to the Virginia Code and say, look, there I am. You can't take a discriminatory action against me, and that's a really good thing. And it's a good thing that it's not just employment, which we'll talk a little bit more about, but housing, public accommodation, and credit, because There have been longstanding issues around fairness and credit for a lot of these groups of individuals, dating back to redlining and other mortgage discrimination. And, in public accommodations, what this means is you now have a state statute that says that you can patronize businesses without fear of discrimination across the board. Anybody who holds themselves out as a public place, whether it's a shopping center or a small business or some kind of recreational park, all of those things are public accommodations, which are now you're protected from being discriminated against if you are in those places. So, I mean, it's really monumental, and it's truly historic that we've gone here, and it is an added wonder that we are the first Southern state to extend these kinds of protections to LGBTQ people.
Yeah, and for folks on the chat who might be thinking, okay, great, how do I use these new protections? What do I do? I think we should talk a little bit about that. So the law goes into effect on July 1st. So it means that anything that happens to you after July 1st will be covered and eligible for filing a claim. I'm most familiar with employment, so I will talk about that. And Claire, you should feel free to chime in for anything on the other areas. But if you think that you have been discriminated against on any of these bases relating to employment or housing or public accommodations or credit, fill out an intake with us on our website, acluva.org. But the process that the new law sets out, at least for employment, is that the protections apply to employers with more than 15 employees. This tracks sort of with federal law relatedly, and you have to file your complaint within 180 days of the instance of discrimination. So if you were fired, within 180 days of being fired, or if you it was a racially charged comment made at work, within 180 days of that incident. If you were denied a promotion, within 180 days of that file. And the first step is to file a complaint with the Virginia Division of Human Rights. You can have a lawyer when you do that. You are entitled to that if you want one. So you can talk to us at the ACLU or a private employment attorney to represent you while you file that complaint with the Division of Human Rights. And under the new law, the Division of Human Rights has to investigate the complaint or tell you they won't be able to investigate it fairly quickly. They will notify you of the outcome of their investigation or tell you that they're closing their investigation without findings, depending on what happens. And after that, you have the right to file your own lawsuit. And it's important to know that you can file your own lawsuit regardless of what the investigation finds. You just have to get that letter from them saying that they have concluded their investigation and you now have the right to sue. It's called a right to sue letter by many employment attorneys. And one of the things, we have hopped over to the gaps note, and one of the things that we're waiting to see how is going to be sort of implemented, the law is very clear that there is a 180-day deadline for filing that complaint with the Division of Human Rights, but it only says that you have to file a lawsuit within a reasonable time from getting that notice from the Division of Human Rights. So we don't exactly know what that reasonable time is going to be yet. It's ultimately probably going to be a matter of court interpretation, but we're keeping an eye out to see if the Division of Human Rights issues any guidance to help people figure out what exactly that reasonable time might be. So it's certainly something we at the ACLU are keeping a close eye on. But then you have the right to go to court and sue and allege all of your charges of discrimination. Did I leave anything out, Claire?
No, and I think one thing to point out, just to provide context and history, there used to be a freestanding Human Rights Council, but now we're referring to something called the Division of Human Rights, which is actually a division of the Attorney General's office. And it's that body that's been given the authority to help, to enforce this law and to independently investigate and to bring suit on behalf of people that they think have been discriminated against. So that's a little bit like the way the federal law works. The EEOC, for example, in the employment context, always has the choice as to whether to issue a right to sue letter to an individual complainant or to bring an action on behalf of that person as the EEOC. And I think we're going to see something very similar to that, evolve in the AG's office, given the authority they've been given. So it's just, we aren't the only state that houses their human rights enforcement agency in the Attorney General's office. It's also true in New Jersey, for example. So that's that's not unusual, but that's what DHR is. It's part of the AG's office.
Yeah, and I think that's a really important clarification. That is a good point that I left out, that for really egregious cases or cases that they're particularly interested in, the Division of Human Rights can bring suit themselves, and the state can essentially go after really bad actors in these areas, which is another important avenue. The state has a lot of resources that we would love to see them really use to go after people who are discriminating in really awful ways. Do you see a question about bullets? So why don't we talk a little bit about some areas for potential future improvement and further strengthening of this act. We in no way want to say that this law isn't super important and a huge landmark piece of litigation, but we would be bad advocates if we weren't always looking for ways to further strengthen the protections and make sure that they're really accessible for everyone. So the first bullet doesn't apply to all employers. It's talking about that cap on, or the floor, I guess, for the number of employees. The employment protections only apply to employers that have at least 15 employees in most cases. That tiny carve out, if you have more than 5 or less than 15 employees and you fire someone for a protected reason, does still exist as well, but it doesn't cover any other types of discrimination at smaller employers. And so we think that these protections should apply to all employers regardless of where they work. We know from some of our intakes and some of our work that there is discrimination that happens in a lot of smaller employers who think that they're exempt and that none of these laws apply to them. And unfortunately right now, besides for that termination exception, they really don't. And so in coming years, it would be really helpful to all employers to make sure, or to all employees, excuse me, to make sure that these protections do extend to cover all employers. So that's certainly an area we're going to be looking at.
Yeah, and that sort of highlights that this extended all these protections to private employers, but it also makes very clear that everybody in state and local government, from teachers to public defenders to college professors, everybody who's employed by a state or local government is also protected by the statute. So,
yeah.
So the private sector is a little more limited, but it doesn't matter where you're working. If you're a state or local employee, you're covered by the statute.
Yeah, that's really important to know. And about a quarter to a fifth, depending on how recent the data is, I don't know off the top of my head, but just for context, about a quarter to a fifth of Virginia employees work at a company with fewer than 19 employees. So that gives you a rough idea of how many people we're talking about that are unfortunately left out of some of these protections that we hope will be covered in future years. That second bullet point is a little bit about what I was talking about, that the deadline is 180 days, but there isn't a specified deadline for how long to file a lawsuit. And so we would like to see that just clarified in the statute. And that does tie in to the question we got on the chat about what bullet 3 means. We just want to make sure that as this is going forward, the process that employees need to use to access these protections is really clear. And that clarifying that deadline is one of those things, but as this gets implemented, this is a huge change in law. We're sure there's going to be road bumps along the way, and we want to make sure that we're doing what we can and that the Division of Human Rights is doing what it can to make it really clear to workers if they feel that they've been discriminated against. Where do you go? Who do you talk to? How do you get this process started? And so we'll be keeping an eye out, and we'd love to hear from people who are trying to navigate this process as well. What problems are you encountering, and what ways can we sort of clean up the law and make it a little bit easier for everyone to have access to these protections?
Yeah, and we would extend that obviously to making clear how, we have very specific rules with respect to fair housing complaints that are part of longstanding fair housing law that this, complements and adds protections to. So there is a pretty well-defined process for bringing housing complaints through the Fair Housing Office. But, public accommodations, not as clear. And so it's really important that we keep an eye on how this is being interpreted and how the Division for Human Rights is managing these complaints as they come forward.
All right. So the Virginia Values Act was not the only exciting new protection added this year in Virginia law. So if we can go to the next slide, we can talk about the next big area. So related, but a little bit separate, Virginia also passed the Pregnant Workers Fairness Act. It joined a lot of other states that have been passing these laws recently. Prior to this law, federal law is sort of a patchwork around pregnancy accommodations and protections due to a complicated and messy legal history that's probably not worth really diving in deeply to. But what the Pregnant Workers Fairness Act sought to do and accomplished was to really make it very clear in Virginia what Virginia employers' obligations are to their pregnant workers. And so the bill as passed guarantees that any employer that has at least 5 employees has to provide reasonable accommodations for pregnant or breastfeeding workers or workers who have complications related to childbirth. The process is not just go in and immediately say, I'm pregnant, now you have to give me everything I want. There's what they call an interactive process where the pregnant worker has to go to their employer and say, I'm pregnant, here are the accommodations I need, and then they have to work with their employer to find out what is reasonable. The law does not require any employer to build a new lactation room and a completely new building that they didn't have. That wouldn't be reasonable. That would be a big burden on the employer. But it does require that there be, for example, a separate space in whatever your workplace location is and whatever that setup might look like. But so that someone who needs to pump breast milk can do that while working and have the break time they need to do that, for example. The bill as passed also explicitly prohibits termination and discrimination due to pregnancy, lactation, or a related medical condition. This is where we're doing this on June 24th. We will see how the law actually gets codified on July 1st, because you might remember from my earlier slide that the Virginia Values Act also included protections. So we're waiting to see exactly how these 2 bills get reconciled and put into the code. We at the ACLU of Virginia certainly hope that the protections in the Pregnant Workers Fairness Act are going to be recognized as separate, because they do go a little bit farther in the bill as passed. One of the big significant differences is that the Pregnant Workers Fairness Act as passed provided a 2-year statute of limitations to file a lawsuit, and it lets people go directly to court. And the reason behind that, the advocates, including myself, who were telling legislators why in this context it was particularly needed, is if you think of pregnancy is an inherently time-limited condition. So you need to get those accommodations quickly, and when you're pregnant, you don't need to be worrying about, can I get this accommodation? Am I gonna lose my job if I don't get it? Do I have to accept something that's not really gonna meet my medical needs? And so we felt it was really important that people who go through that interactive process with their employer, they already have that level of protection on the employer side of being able to negotiate for what is reasonable and what the employer to do. But if that process doesn't work, that they be able to go right to court immediately. And because when you're pregnant, hopefully if everything goes well, the end of the process is going to be a new baby that you then also have to rearrange your life around. We asked legislators, and they did pass a 2-year statute of limitations to go to court with those claims, recognizing that someone who is pregnant and either lost their job due to discrimination or had to take a pay cut or didn't get the accommodations they need, their first priority in their life at that moment might not be, how do I get to court and fix this, and how do I get damages to be made whole. And so we asked the legislature to pass that longer statute of limitations. So we're hopeful that when it's codified, that intent is going to be recognized, and we're certainly keeping a close eye out on how it's codified. And it will be an area for future improvement if it doesn't get codified, to recognize that explicit sort of recognition of that longer statute of limitations for these cases was intentional when we were trying to.
It feels like there are really 2 things: the recognition that you don't have to go through the administrative process, you can go directly to court, and that there's a 2-year window. We had a good question though about pregnancy accommodation that I thought it might be good to raise now, because you were just talking about that, which was that the person said, when I was pregnant, I found I had more energy in the morning, and I was a wage worker in a grocery store, and I asked for morning shifts, but they didn't receive them. Is that the kind of accommodation that you're talking about that someone has a right to under the new law?
Yeah, so I think it would really, unfortunately, we're going to give the frustrating lawyer answer of it depends. The accommodations that employers are required to provide is what is reasonable. And so that's going to take into account what positions do they have open, what are the needs of the employer as well as the needs of the employee. So if you're one of 2 people and you are explicitly hired, to do a night shift, and they don't have a need for a morning person, that might not be reasonable. They don't have to create new work for you explicitly. But if they have an open morning shift, and that would be helpful, and there are, lots of open spots and someone can cover what would have been your old shift, that's a situation where a court is more likely to say that that's a reasonable accommodation. So there is a lot of guidance on the federal level of how these sort of reasonable accommodations in this interactive process has been negotiated. You can find that on the EEOC website, which is eeoc.gov. But those are the types of things they're going to take into account. They're going to look at what are the circumstances of the employer and what are the medical needs of the employee. Really good question. Thank you.
Yeah, I think it was a great question. And then someone had a question that before we move on about how long do executive orders stay in effect. An executive order is entered by a governor, and it can have a deadline in it. I mean, it can say this order expires on a certain date, or it can extend until it's revoked by a succeeding governor. So in the case of the executive orders on state employment, they've always been the first or second or third executive order signed by a governor when he, takes office. And that tradition actually was started by Governor Linwood Holton many years ago. And the only time that it was changed significantly was when Governor McDonald first took office. He did not make equal employment opportunity for state employees his executive order number 1. So and as I said, the executive order now becomes way less important because now there's actually a code section that says you have a right not to be discriminated against as a state employee. And there's specific remedies that are available, which were not available under the executive order. Again, the executive order was kind of like a statement of policy without any teeth to it.
And I also see another question in the chat about whether suit can be filed in federal court. So I'll give my typical important lawyer disclaimer, this is not specific legal advice to you, and you should talk to a lawyer specifically looking at your case. And if you want that to be the ACLU, you have to fill out an intake for us to do that. But generally speaking, these are state laws, and the primary venue for bringing them would be in state court. It's now the first time you can go to state court directly with these claims, both on pregnancy and if you go through the administrative process under the Virginia Values Act. That being said, to get a little technical for the lawyers who might be listening, there are circumstances in which you can bring a state law case in federal court if you are bringing related federal claims. So that could be a possible option. But I have certainly been talking to the plaintiffs' attorneys, the private plaintiffs' attorneys here in Virginia, and there's a lot of optimism that we may be able to, because we have brand new law and we're setting brand new precedent, there may be opportunities to push our state law protections even further than the federal protections. Generally speaking, federal law is a floor. It's a minimum of the amount of protections, and states are free, and that includes state courts, to provide additional protections above federal law. And so a lot of the plaintiffs' attorneys are thinking really creatively about how we might be able to really push Virginia's protections above that federal floor. And that may mean only bringing states in state court so we don't have any of the limiting precedent brought in by federal court. So talk to your lawyer about your specific situation and what makes the most sense. But I am definitely personally interested as a plaintiff's attorney and thinking really creatively about how we might be able to bring claims in state court to really provide actual additional protections for Virginians. And that includes federal law has damages caps, and the Virginia Values Act doesn't currently have cap damages in employment case. So you might be able to recover more under the state law than you could in federal court.
Okay. I guess we're ready to go to the next slide.
And Lee, I am not ignoring your question. We are going to get to that in just a minute. So one other area we wanted to highlight that was a really big win for gender equity this year was in the area of abortion access. Some of you may know that for years and years, Virginia has had these really troublesome targeted regulations of abortion providers, or trap laws and regulations as we call them. We are currently involved in a lawsuit trying to overturn them, but we were able to get a legislative win this year to repeal some of those burdensome protections. The two that probably, if you have ever tried to access abortion in Virginia, that you probably came up against the hardest and most clearly were what we call the 2-trip mandatory delay law. And that was a law that required anyone seeking an abortion to have an ultrasound and be offered the right to view that ultrasound. And then they would have to wait at least 24 hours if they lived within 100 miles of the abortion clinic or abortion provider before they could have the abortion. So effectively, it required that people seeking abortion make 2 trips to get their abortion that wasn't medically necessary. And that law was repealed. So after July 1st, you will not need to make those 2 trips anymore. There were also a whole series of laws and regulations that affected the way that abortion providers specifically were regulated, that applied to anyone who provided 5 or more abortions per month. So any home doctor or general practitioner or OBGYN who wanted to provide 4 or fewer a month could still do that without coming into any of these regulations, which may give you an idea about whether they were actually medically necessary or not in the first place. Would have to meet all sorts of really burdensome regulations that weren't really applicable to the provision of abortion. And so those laws are also being repealed, and we anticipate that the accompanying regulations will also be repealed. So we're really excited to have these laws repealed, and I'm very hopeful that they'll make it a lot easier for patients to access abortion care in Virginia.
Yeah, I think, you know, just going back and adding a little history and context, you know, Virginia, when Roe versus Wade came down, Virginia didn't immediately seek to comply. At that time, we had on the books, and we still have on the books, a law that says it's a felony to perform an abortion in Virginia. And when the case came down, they were loath to change the law, so they just amended it to say, well, it's a felony in Virginia unless you meet certain standards, and the standards had to do with, you know, who could provide an abortion, what kind of facility you needed to be in, and that sort of thing. And we ended up with some of the most restrictive abortion laws in the country in the criminal statute where they still reside. And you know, informed consent and the 24-hour wait and the trap regulation, they're all things that create these exceptions to the criminal law. And, you know, I think most people don't recognize, you know, that there's still an overarching criminal standard that applies here that we, you know, when we talk about things we want to fix, would be something that might be a next stage. But I think they also don't realize how incredibly onerous our laws were. And at the same time that our legislature was dragged by a lawsuit into making some amendments to the criminal prohibition, they also passed one of the most comprehensive so-called conscience clauses in the country that says that no person working anywhere in any job and no facility can be required to perform, you know, provide abortion services. And it also says, and if their decision not to do that causes actual harm to people, they're immune from damages. And so, I mean, it's really an outrageous statement. And, you know, one of the things that we talk a lot about is the importance of removing the stigma from abortion and making clear that abortion is healthcare, and any healthcare provider should be able to hand you a pill for a medication abortion without there being any need for the government to be in the middle of that conversation, for example. And also the procedure is not surgical because it doesn't involve any cutting. So the medical procedure abortion similarly should and could be done in doctor's offices, just like other kinds of similar procedures. So what we're really working toward, all of us, I think, eventually, is an understanding that abortion is healthcare and it needs to be regulated just like healthcare is generally, and providers should be providing healthcare without discrimination to everyone.
Exactly right. I think we can go to the next slide now. So there were a couple other wins that we wanted to highlight, and that first one gets to some of the questions in the chat. So just because we pass like new excellent protections in Virginia, the fight doesn't stop at the federal level. We're grateful in Virginia for these protections, but I personally would like to see them extended throughout the entire country. And I think that's generally the position that we have here. To that extent, we were really excited to support ratification of the Equal Rights Amendment this year. The Virginia legislature became the 38th state, the last state needed. And so now should get added to the Constitution. Some of you may know there are court lawsuits that we are not involved in about whether that's going to happen. But we're proud to say that Virginia did our part and is on the right side of history on this issue. And I know Claire can talk a little bit about the history of the Equal Rights Amendment in the state of Virginia, because many people don't know that we also have one here in state that has been sadly curtailed by our Virginia Supreme Court.
You know, and it's so interesting, Nicole, because when I testified in favor of the federal Equal Rights Amendment way back when, one of the key arguments against passing it or ratifying it in Virginia was we didn't need it because we had a constitution in 1970 that included a state equal rights amendment. And our state constitution says, you know, sex discrimination is unconstitutional. unfortunately, we also have a Virginia Supreme Court that has consistently sort of said that the Virginia Constitution and the federal Constitution should be interpreted, sort of coextensively, because they were, quote, written by the same guys, sort of thing. And yet they've completely failed to recognize that 1970 was a long time after those people they were talking about wrote anything or were even walking on the face of this earth. So, one of the things that we've talked about from time to time is there a way to make our Virginia Equal Rights Amendment in our Virginia Constitution have more meaning? And certainly if we continue to blow these many 40 years later, have to continue to fight for a federal amendment, I think, we should be looking more carefully at making the Virginia amendment actually mean something. It is interesting. I was laughing because the first time I ever talked about the Federal Equal Rights Amendment was at a legislative hearing on it, and the person on the other side was Phyllis Schlafly. So if you're watching Mrs. America, you kind of know what I was up against.
Thank you. Yes. I was just checking the question chat. Sorry for the distraction. So the other important thing that we wanted to highlight was the passage of the Crown Act. And this is related to the Virginia Values Act. It sort of lives in the same piece of the code, but it's a really important additional protection to call out explicitly. Virginia was the 4th state in the country. This is a really new movement to explicitly add hairstyle discrimination to the definition of race discrimination. So this means you can't discriminate, or employers can't discriminate against people for wearing their natural hairstyle. You can't discriminate against someone for choosing to wear their hair in an afro or dreadlocks or other hairstyles. People are allowed to pick whatever hairstyle they want. There was the sort of history of this movement really briefly is that there were some bad court cases where people brought challenges saying like, look, my employer is discriminating against me just because of the way I'm choosing to wear my hair, but the way I'm choosing to wear my hair is a direct result of my race. It's because, I'm wearing dreadlocks because I'm Black, or I'm wearing an afro because I'm Black, and that's how my hair naturally comes out of my head. And sadly, the courts really got this issue wrong, and they said that that's a uniform application, and it wasn't covered under race discrimination. And so states, including Virginia, have been taking it upon themselves to really add explicitly through the Crown Act and make it very clear that we think those court decisions are wrong. And here in Virginia, it is race-based discrimination to discriminate against someone for wearing a natural hairstyle. And so what this means in practice is that all of those new protections under the Virginia Values Act for race discrimination cover protection based on how you're choosing to wear your hairstyle. And it's exciting. There's not a lot, it's a really interesting new area of potential litigation because like I said, we were the 4th state to pass it with right behind New York, New Jersey, and California. So Virginia isn't typically grouped in with those states, and it's exciting to be at the front edge of this legal issue. 2 additional states that I don't remember off the top of my head right now, but have since also passed it, and Montgomery County in Maryland, I think, also passed a countywide ordinance. So it's exciting to see that these are being added, and we hope more states will add them too. But I'm excited to make use of this in Virginia. So again, file an intake if you've got an interesting case under this, and that'll also go into effect on July 1 with the other protections. And the last area we wanted to highlight is an area that made some news right before the legislative session, and that we at the ACLU have been pretty involved in. So we wanted to make sure that we got these protections really highlighted. Some of you may remember, sadly, late in the fall, there was a really terrible, terrible incident where a child trying to visit her parent at a Virginia Department of Corrections facility was strip searched. And that is awful. And no one should have to undergo a strip search in order to see a loved one, but certainly not a child. And thankfully, there was public outrage around this, and VDOC announced at the time that they were suspending this policy and they wouldn't be strip searching minors anymore. But we felt that it was really important to add that prohibition explicitly to the code. And we at the ACLU of Virginia have also been receiving intakes about the use of visitation rights and to really pressure people into consenting to these strip search in ways that are really problematic. If you're being given a choice between consent to a strip search or possibly not see your loved one who's incarcerated again, that's not a real choice. And so we wanted to make sure that there were also protections against the Department of Corrections from giving people with that false choice and obtaining consent under those circumstances. So we were able to work with 3 different legislators who all introduced legislation to try to address this issue. And I'm excited to say that all of those laws did pass. So the protections that went into place, there's an explicit ban on strip searching of minors specifically at VDOC facilities. And there's also an explicit prohibition in the code now that says that VDOC cannot deny you future visitation because you deny a strip search that day. They can still say, we suspect you have contraband on you. We're not letting you in today if you don't consent to a strip search. But if you decline that strip search that day and leave, they can't say in the future, you declined strip search last time you're here. We think you're suspicious. You can't come in. They're explicitly barred from doing that. So we're going to be monitoring implementation again of these new protections. We want to make sure people who are going to visit loved one in prisons are aware of them. And should you have problems, again, reach out to us via intake, because we want to make sure that these protections are being properly enforced by the Department of Corrections. And we're really excited to see that they are in the code and they're not going to be left up to the whims of future administration. Just because this administration repealed them, you know, if we hadn't gotten the protections in code, a future administration could have changed it. So now that it's in the law, we are excited that these protections are here for everyone.
So Nicole, does this address directly and completely the problems that people were having who were using feminine hygiene products and being subjected to you know, scans and strip searches as a result of their choice of feminine hygiene product? Is that still an issue and something we need to continue to be concerned about?
Yeah, so sadly it does not. It doesn't completely address that issue, like you said. We want to make sure that people who are visiting their loved ones in prisons are able to use the menstrual products that we need. The administration has made some announcements around people who have had, I guess the context here is that we have received reports of people who were flagged for using menstrual products, asked to do a strip search, still denied their visitation after they consented to the strip search, and even some reports of people who were permanently denied their visitation rights. The administration did say that anyone who has had either a temporary or permanent ban on visitation due to a denial of a strip search, which we know in some cases has been related to the use of menstrual products, that they should get in contact with the Department of Corrections, and they will have that ban lifted, or they'll consider lifting that ban depending on whether there were other circumstances related to it. So we definitely encourage people to do that. But if you're trying to navigate that process and it's not working or you're being denied, we also want to hear from you, because we want to know what the Department of Corrections is doing. And the other thing to note is that we don't know exactly how that process is being played out right now, because due to the current COVID-19 crisis, visitation is severely limited in Department of Correction facilities. And so because access to visitation is so limited right now, we don't know if and how these regulations are going to be implemented, how people are going to end up navigating this process when things do open back up. So we hope that you'll keep in mind that these protections exist, and once you're able to go visit your loved ones again, get in contact with us if you're having problems, because we want to know how these things are being implemented.
So let's look forward.
So we highlighted a couple different areas where we're going to be continuing our important gender equity work here in Virginia. The first one, and this was the area where the legislature really let us down in the General Assembly this year. We know that there are certain provisions of the criminal code that disproportionately affect women. And what I mean by that is we know the pathways to women into the criminal legal system are different than those that typically have men. When you look at the numbers of people, the ways women get involved. And we know that women are most likely to, one of the top 3 reasons that women find themselves wrapped up in the criminal legal system is due to property-related crimes or crimes of poverty, so theft and things like that. So knowing that, 2 of the important laws that can do a lot to reduce the number of women finding their way into the criminal legal system are increasing the felony larceny threshold. That's a lot of words, which basically means the dollar amount of whatever someone has stolen over a certain amount, it automatically becomes a felony instead of a misdemeanor. They raised the cap a little bit this year, but we here at the ACLU think that it should really be up to $2,000, and I think they went up to $1,500 this year, Claire?
1,000. We went from 500 to 1,000, and the national average is, I think, 1,500. And the data from all the states that have increased their felony threshold shows that there's 0 increase in crime. There's no increase in shoplifting, and there's nothing that's a countervailing factor here. But you know, any kind of increase in these thresholds has been usually very hotly debated as a result of the lobbying of the retail industry. And so, we just have to keep pressing for that. I think the other piece of this that was really disappointing too was there's another little law that says if you shoplift or you steal 3 times in 3 different incidents, and that it can be a bag of potato chips each time. Those are each misdemeanor offenses because they're below the threshold. But if you do it a 3rd time, it's a felony. And we tried to get the 3 strikes and you're a felon provision out, because again, these are crimes of poverty for the most part, and these small these small nonviolent thefts should not be something that results in somebody being felonized, including loss of civic privilege and voting rights, because it doesn't matter how de minimis your felony is. If they call it a felony, you lose your voting rights for life until and unless you complete your sentence, and until and unless a governor decides that he or maybe she someday will give it back to you. So, they're just the other place I think that we've highlighted that has a particularly significant impact on women generally and women of color and Black women particularly is the whole way that marijuana is criminalized and regulated. And we worked really hard to get the General Assembly to understand that leaving penalties in place and calling possession unlawful didn't address the discriminatory enforcement issues that we saw with respect to marijuana offenses in Virginia. And the fact that now, as of July 1, you won't be prosecuted for a misdemeanor, but you'll get a civil penalty. It's still unlawful to possess marijuana. That means that if you want to apply for a federal job or go into the service, you have to still say that you violated the law. And in addition, the police can still stop you because they thought they smelled marijuana, because it's still illegal for you to have it. And then the final thing is that they do give you a citation. You have no right to a counsel to contest it because you're not facing jail time. And then they also made juveniles criminals by saying that possession by an adult might be a civil penalty, but by a juvenile, it's a delinquency, which is in juvenile speak is a crime. And finally, they put in a little kicker that says that while possession under an ounce is presumed to be personal possession, there's a rebuttable presumption that allows the police and prosecutors to still prosecute you for felony intent to distribute if they think they have facts to show that. So, what we have going into effect on July 1, you can argue that it's better than what we had before, but it is nowhere near a bill that is going to change the dynamics and the racialized war on drugs that's been ongoing for a while. And, we're not going to give up until we get to full legalization. But what we were able to do in this session was hold back a tide of additional criminalization in some ways, and not be very successful in protecting the people who've been victimized by our current drug laws, Black and brown people particularly, and women. We just weren't as successful as we would have liked to have been. So there's a lot of work there. One of the most exciting things, I can't let everybody go today, and we're getting close to the end, but without talking about how exciting this new special session that is going to happen in August is going to be. The Legislative Black Caucus put out their agenda today, which includes legalizing marijuana as part of the criminal legal system reform that they're advocating get taken up in this special session. And, I think it's a real opportunity to begin the process of reimagining police and reinvesting some of the dollars we're spending, the $400 million in state funds that we're spending on militarized police, on public health and public welfare programs. So, I'm really excited about maybe making some additional strides this summer and not having to wait till the 2021 legislative session next January for some of this looking forward. Maybe we don't have to look too far forward to make some real and important changes.
Yeah, and that's super important. And I'm glad you lifted up the special session, because it's really important to make sure people know that that's happening and they can contact their legislators for some of the changes they want to see. The two other things on this slide really quickly before we get to some of the questions, strengthening anti-discrimination protections. We covered some of that before, but we just want to make sure that the new laws are accessible to everyone, and we're keeping an eye out for the way that those are going to roll out, and seeing if there are either just technical, simple fixes that legislatures are usually pretty willing to make to just fix things and make them work a little better, or as well as some of the bigger changes, like making sure that the protections apply to all employers. Those are the types of things we're looking at to make sure that those protections are as strong as they can be. And finally, like Claire mentioned, in the abortion access piece, abortion is still in the criminal code in Virginia. Other medical procedures are not. There's no reason for it to be there. It just doesn't belong in the criminal code, and we would like to see it taken out. But Claire, I know we have a question in the chat around restoration of rights and voting that I am sure you're quite eager to address since we've got some time left.
Oh yeah, no, absolutely. So at the ACLU of Virginia, we have started to talk about issues related to the way that our laws felonize people, and then that impacts their voting and their civic privileges. We've started talking about that it's time to stop talking about this as something where you get something back, and rather talk about it as something that you don't ever have to have taken away from you in the first place. So we're working very actively with a number of people. We have a proposal that's pending in the General Assembly that was carried over and will be considered in 2021 to amend the Virginia Constitution to delete completely both the Jim Crow and the eugenics provisions in our Constitution. We have two provisions in our Constitution that limit the ability to vote. One is the Jim Crow provision that says if you are convicted of a felony, you lose your voting rights for life unless the governor chooses to give them back to you. And the other is a provision that says if you are found to be legally incompetent, you lose your voting rights, period, until somebody determines that you're competent again. And one of the things we've learned over time is that people have different levels of ability, and somebody who the courts think might not be able to balance their checkbook could still be very much competent to be able to make decisions about who to vote for. And so, this is an appendage and an appendix, a vestigial organ of the time when Virginia was actively engaged in the eugenics movement. And these two things, came together with, efforts to characterize Black people as feeble-minded, and then to keep, quote, feeble-minded people out of the country. We have laws that say that if you check into a mental health facility in Virginia, they're supposed to check your immigration status. All those things date back to the 30s and early 40s when we had an active eugenics movement in Virginia. And so we need to take both of those provisions out of our Constitution and have it say that if you're 18 years old and you're a resident of the Commonwealth of Virginia, and that you can vote, and nobody can ever take that right away from you. Doesn't matter who you are, where you are, what you've done, you remain as a voting member of our community, and you have a right to express your point of view at the ballot box about policies and laws that affect you, and elected officials who are making decisions that affect your life and the lives of your family. So we'll be working very hard to get a first positive vote on the constitutional amendment in January, and then that would mean that we would be on the road to putting it on the ballot for everyone to vote on in 2022. And in the interim, people who have been disenfranchised should continue to check in with the Secretary of the Commonwealth and see if the governor's current policy would automatically re-enfranchise them. But in the long run, we want everybody to join us in being advocates for a guaranteed right to vote that government can't take away from you ever, because, voting is the essential currency of democracy, and it belongs in your wallet, and government shouldn't be able to take it out of your wallet or mortgage it or tell you that, in its allowance they gave you and they're going to take it away unless you're good. I mean, honestly, really. So, I'm excited about that. But in the short term, there is a process still where people who have been disenfranchised, can immediately get their rights restored, and you can access that process on the Secretary of the Commonwealth's website. And it is automatic if you have finished your probation and parole and you're no longer subject to the jurisdiction of the Department of Corrections. But in the other final piece I'll say is this fall, I hope all of you will help us make sure that people who are housed in our jails, who are for the most part people awaiting trial, or in some cases convicted of misdemeanors, who've never been convicted of a felony, every one of those people has a right to register and vote absentee today. And we need to make sure that people know that they have that franchise and that they should be feel good about executing it. We should be talking to the sheriffs and the superintendents of regional jails about making sure that people in their facilities are registered and have the option to vote absentee.
Yeah, and so the explicit answer to the question in the chat about whether people in prison or jail who have not been convicted of a felony can still vote in Virginia, and the answer is yes, and we want to make sure that people know that they have that right and know how to access it. And so we do, we have information on our website, and we'll continue to update it as we get closer to Election Day and as deadlines come up. So keep an eye on our social media channels and on our website for information on how to, for everyone on how to make sure you're registered to get your absentee ballot if that's how you want to vote. And to make sure that people who have loved ones that might be in jail and have the right to vote, that they know how to exercise it.
Yeah, the special session will be live streamed. So, and they do a pretty good job these days of live streaming committee meetings and the actual sessions. I think there's every possibility in the world this is going to be a virtual session. At the end of the last session, actually, I think even the day of the reconvened session, the General Assembly passed some rules that allowed them to meet electronically as opposed to having to meet physically. And we have some concerns about that, but I think that I think it's quite possible that they will convene the special session digitally as opposed to physically, but we don't know that for sure, and we're sort of waiting to see what that looks like. But in any case, if they follow their current policies, you should be able to watch it all live on camera and a live stream, both if committee meetings and the full session in real time through the legislative website.
And as far as getting involved goes, I mean, luckily nothing about the current crisis prevents anyone from calling or writing their legislators about any of the issues that are important to them. And if you sign up for our mailing list, we send out action alerts on things that we're working on that sometimes include, you can add your name to a petition or even a direct form to email or contact the governor or your legislator directly. So if you're not on our mailing list yet, you can sign up at our website again. And we also share those types of action alerts on our social media channels. So follow us on Twitter and Instagram and Facebook to keep an eye out for the opportunities to get involved directly with what we're doing. But certainly keep calling, keep writing your legislators. They need to hear from you now more than ever. So I think it looks like those are all of the questions we had. So thank you so much, Claire, for doing this with me.
Yeah, no, Nicole, it's always good to spend time. I always learn something new. I hope that we've been helpful to folks who've been watching today, and we're always grateful for questions on our Facebook page. We try to be very responsive when people ask specific questions. If there are answers that can be given that aren't legal advice, because we can't do legal advice on our Facebook page. But we do have an intake process which you can access on our webpage if you think you've been discriminated against or your civil rights have been violated. And we encourage people to do that. And then as a final note, let me just say that one of the things that you can do today, given what's going on in the world, is you can download our mobile justice app and make sure that you record what you see when you see police or ICE or anybody interacting with members of the community in public. You have an absolute right to film. And the one nice thing about the mobile justice app that a lot of people don't know that they can access is there's on the app itself, there's a little know your rights provision that talks about your right to film and also your other rights in a protest situation or in a situation in which you're interacting with the police. So it's a really useful thing to have. And if you have it on your phone and you do record something, that recording not only lives on your phone, but it automatically uploads to our website, which means if
not publicly on our website, it gets sent to us.
A private confidential
Yes.
server, I think of the cloud, but it automatically loads to our private confidential server where it is maintained. And so if you're in a situation in which you do get taken into custody and they take your phone and seize your phone, then you know that your video is secure with us. And if it documents something that is a violation of rights, it's maybe something that we can respond to, sometimes not, but we look at everything and make decisions about where we can help. So somebody asked one last question, did I see on the chat?
Yeah, there's a link to download the app that we dropped into the chat, so you can take a look at that, and it talks a bit more about it. It is a Virginia-specific mobile justice app. I don't know the technical details of who built it, if it was national or us, but there is a Virginia-specific app that comes to us in Virginia directly.
Yeah, this is it was built in conjunction with a couple of other affiliates, and all of the affiliates that have the app have specific state versions. So when you go to, you know, a Google Play or wherever you download your apps from, you need to be sure that you're downloading the Virginia specific app, because that's the one that's linked to us. And I'm sorry, Chris, the answer to your question is yes, you still don't get your, you still cannot get your right to vote restored by the governor until you've finished all the terms of probation and supervision. The governor could choose to change that if he wanted to, because he has complete discretion to decide the terms on which he's going to give people their rights back. But I mean, I think one of the things people don't understand is we felonize 12,000 more people a year. And this governor's done, I think, 11,000 restorations. And there are 300,000 people potentially who are disenfranchised right now. And we sort of did a projection and tried to figure out rate of response. And we were thinking that the backlog would get cured, you know, in 30 years. That is why we're in favor of not having that happen, and for everybody to have the right to vote at age 18 that can't be taken away and isn't subject to that kind of process.
It looks like at time. So thank you everyone for your really thoughtful questions. And thank you, Claire, for such a good discussion.
Thank you, Nicole. And we, you know, this is, the ACLU of Virginia is trying really hard to do all the things that we want to do using all the tools that we have. And so we look at a goal and we say we want to get to a specific goal, and sometimes we get there through the courts, and sometimes we get there through legislative action, and sometimes a huge part of it is talking to people like you and engaging in public education as one of our most important tools. So thank you all for being here today. Thank you for your interest in this topic. And thank you for helping us raise the visibility of what happened in a way that might inform you in terms of your daily lives. So bye, thanks.